We look at this right here, right? Big U filed this in court, right? With the United States of America. And you see this right here. It tell you the United States of America versus Eugene Henley Jr. Hold up. You ain't got no advantage against these people that, run the game. Straight up. And we gonna get into this, man. Make sure you smash that like button and hit that subscribe button, man. This right here gonna let you know that they playing games with Big U. They don't want to give Big U, his discovery. They playing with his legal mail. They got him confined. They throw you in the hole, in the shoe, and they move you to different units so that you don't have the leverage. They throw your whole balance off. Straight up. It's a dirty game. You know what I mean? Straight up. Let's check it out. All right. So, Dear Honorable Fernando L. Anel Rocha, District Judge, I respectfully submit this letter and enclosed declaration for the court's awareness regarding conditions that have both existed and newly developed during my pretrial detention at MDC Los Angeles, and the ways in which those conditions have affected my ability to review my discovery, communicate with counsel, and meaningfully participate in the preparation of my defense in this case. It is important to me that the court understand that I am not filing a motion and I am not requesting a continuance or additional delay in these proceedings. In fact, absent being granted bond, I will always assert my speedy trial rights. The purpose of this submission is to provide the court with an accurate record of my circumstances, including events that occurred after my original detention hearing, and to explain how those conditions affect my ability to exercise my constitutional rights while my case is pending. Like, they play dirty, man. We all got constitutional rights, but that don't mean that they're gonna abide by them. And this is what people gotta understand. The enclosed declaration describes in detail my placement in admission detention, the seizure and non-return of my legal materials and discovery, USB, limitation on discovery access, interruptions in medical accommodations, continuing legal mail issues, the investigation hold on my trust account, and the failure to carry out a prior court order relating to the death of my son while I have been in custody. I have also described the steps I have taken to raise these issues internally and through institutional channels. So we see here, right? They're playing with his legal mail. They're not providing the whole discovery. They took the USB drive, and the judge ordered Big U to be allowed to go see his son without everybody around, and allowed him to have a virtual, viewing of the funeral, right? And the feds denied all that. After the judge ordered this and playing with the legal mail, man, listen. This is what people got to understand when you're running around the streets, that the game is played unfair when they get you. Once they get you, they not playing fair, man. Straight up. They not playing fair. My intentions in submitting this letter is that I am asking the court be aware of these developments and the impact they are having on my ability to participate in my defense, and that the court consider any relief or guidance it finds appropriate. Aside from continuing trial, I reaffirm that I am not asking the court to delay the case. I am trying to move forward and participate meaningfully, but under the conditions prescribed in this declaration, I do not have the realistic ability to do so absent intervention this court deems necessary. If the court believes a hearing, clarification, or further submission from counsel is appropriate, I will, of course, defer in the court's direction. Straight up. Thank you for your time and consideration. Respectfully submitted, Eugene Henley. So, Big U is being handled in this situation. Now, these are the things that people don't pay attention to when you're running around the streets. They get you in these situations and they play unfair. They not playing fair game because it's their game. The hand of one is the hand of all. People got to understand that the prosecutor, judge, and the criminal defense attorney all go to school for the same thing. Straight up. And when you got a public defender now and you locked up, come on now. You think they don't be working together? You think they don't be having those conversations, about what they want to do and who they want to give up and who they want to play? Come on now. And I'm just being real. I already know Big U, did some time, but I don't think Big U has the knowledge of the law. Somebody in the jail, probably, help Big U get this together, or maybe he got his public defender to, submit this. But one thing people got to understand, when you locked up, right, you can't file no motions or anything if you got an attorney. Everything got to go through your lawyer. So, maybe this is why he's saying this and somebody helped him in the jail get this together, because you can't file no paperwork on your own behalf once you got a lawyer. This is how they do you dirty. All right. Big U says, declaration of Eugene Henley. Eugene Henley Jr. declares as follows. I am the defendant in the above captioned case, and I am currently detained at MDC Los Angeles. I have been in continuous federal pretrial custody since March 2025. I submitted this declaration to advise the court that conditions of my confinement and defense that have occurred while I have detained are materially interfering with my ability to communicate with counsel, review discovery, and meaningfully participate in the preparation of my defense in this complex multi-defendant RICO case. My purpose is to give the court a clear, accurate record of what is actually happening to me in custody and how it affects my right and my ability to defend this case. I also want to make it clear at the outset that I am not asking for a continuance of the trial, and I do not seek additional delay. The problems I described do not arise from a lack of time. This arises from the conditions and restrictions that prevent me from preparing at all, no matter how much time is added. While this letter is directed to the Honorable Fernando L. Anarocha, District Judge, and directly from me, it was simultaneously provided to the U.S. Attorney's Office and the U.S. Marshal Service and MDC. Background. I have now been detained for approximately 9 months as of January 2026. From the beginning, I have wanted to move my case forward. I have not asked the court to slow the case down. I have consistently told my attorneys that I want to see the evidence, understand the discovery, and assist in preparing my defense. This case involves very large volumes of discovery, including historical materials, recordings, and records that span years and involve many people. Much of the discovery is subject to protective orders, which means I can only see it under tightly controlled conditions in the presence of my defense team. People got to understand that WAC did some great work. You hear me? We already know that Monster is telling, the guy that he was allegedly extorting. We already know that Morley is telling, the guy that he was allegedly extorting, and that, the studio that he was supposed to be at allegedly with the situation with the little boy. We already know all this, right? Everybody knows this, right? So why would they want to keep the discovery from Big U? because there's evidence in there that they don't want to show Big U, because they got to provide the evidence of what, led them to get certain things. They got to have that documented. And yes, it's documented, but they don't want to show Big U. And we all got the right to confront our accuser and to see the evidence against us. When they don't want to give you certain things, it's a reason why. Some things they might have done wrong. They might have done illegally, but they don't want to show you it. But these are the things that people don't think about when they in the street, because now it's their game. You got to go by how they want to play. You ain't got no leverage if we being real, straight up. So in a case like this, it is essential that I have regular and reliable access to discovery, that I am allowed to keep and review my legal papers, and that I can communicate with my lawyers in a focused way over time. Instead, the opposite has happened. Murder of my son and failure to follow court order. As this court is aware, while I have been detained in this case, my son was murdered. Losing my child while I'm in custody has been among the most challenging experiences of my life. They don't care. In connection with my son passing, the court issued an order related to my ability to have contact or participation. Despite that order, I was not permitted the contact or participation that the court intended. The order was not followed. They don't care. I was not able to be present for my son in the way the court had authorized and made an exception for after his death. I was not allowed private viewing, even though there was a court order for this. Of course, I will never have that opportunity again. They don't care. Straight up. This has caused my family extreme grief and distress. It also affects how I experience my detention. I am trying to process the death of my child, while at the same time being asked to assist in a complex RICO defense with almost no access to the materials or potent discovery. They don't care. The failure of the following the court order about my son's death has also affected my confidence that any institutional promise and or any future accommodations will actually be carried out with or without a court order. When a court order concerns a matter of serious as the death of a person's child is not honored, it is very hard for me to trust the less formal assurance about discovery or access will be respected. I continue to grieve my son. The combination of that loss, the unfulfilled court order, and the conditions described below directly affects my case. See, people got to understand, they don't care. They don't care at all. Not one bit. They do not care at all. Straight up. Big U wasn't thinking about these things when he was on the street. Straight up. They don't care. It's their game. When they get you in their system, they don't care. Yeah, they're supposed to abide by rules. The judge made an order that he was supposed to be able to view the son by himself directly and see the trial version. They don't care. It's a RICO. Man, think about this, man. These are other human beings. They don't care. They run in a system that they run their way. Straight up. You think that you got a fair opportunity. Niggas want to run around these streets playing a dirty game, thinking that the streets love them, thinking that they homies love them, thinking that is love when there is no love at all. Nobody cares when you in this situation. Your family, yeah. But the people that are running the process, they don't care about what you saying. Straight up. They don't care. You know? Now they playing dirty with him. Straight up. You know, Big U wanted to get his discovery so he can see everybody that's telling and involved with the case. He wanted to see everything. They're going to keep it from him. We all know Wack 100. Straight up. Lined the man up. Made sure Loose Cannon told the details. He made sure that Loose Cannon got out there and told the details, man. Loose Cannon was a major part to get Big U. Major. Wack was a key player. You know, these things are documented inside the paperwork. They're documented. You know, they had to document all that shit. Wack and Loose Cannon then told Wack so much information from him being around Big U. You know, Wack made sure he went on there and told the majority. There's things that Loose Cannon told Wack that isn't out there, that Wack knows that he relayed to the feds. Loose Cannon was a blabbermouth, man. I'm just being real. Loose Cannon was a blabbermouth. He wanted to brag about these criminal activities online to Wack. He wanted recognition for being a gangster. This is what happens when you want recognition for being a gangster. I'm just being real. This is why I tell y'all everything with Wack is fufafi. Because when you want validation for being a gangster and you go to the public with it, you just telling the feds. You see Wack talking all this goofy stuff on the internet. He's only talking to the feds, you know, for the feds. Come on, man. This is what he doing for the government. Dude is working hard. Straight up. He working hard, man. You know, got that bull, you know, in the pickle, man. You know, But I call it out. And you see, they can't get Deezy to fall in no trap. They can see that I'm a smart individual. I'm telling you, these people that see me talking about Wack knows I'm not one of them. You're not going to get me like you get these other jokers. You're not going to run that game on me. That shit that you doing, that shit don't work on me. I know what it is. I know you fufafi. Straight up. Legal mail problems and access to case documents. During my time at MDC Los Angeles, there have been ongoing problems with my legal mail. Based on what my attorneys of record have told me, I understand that approximately 25 pieces of legal correspondence were extremely delayed or never reached me at all. I am informed by my attorneys that some of the mailings were even sent with tracking. So his attorneys is sending him the mail and they grabbing it, confiscate. Man, it's a dirty game, but it's their system now. These are the things people don't understand when they run in the street. That's why I say, man, give it up. On multiple occasions, legal mail has arrived to me already open. So, of course, not open in my presence. On other occasions, I have been told mail was sent, but I never received it. These problems have involved important materials such as my indictment and other case documents or legal notes. I believe between 1 and 3 legal professionals can and would declare to the same. See, and people got to understand, right? This the game they playing. You know, when your legal mail come and you locked up, they supposed to allow you to open it up and show them that your attorneys ain't sending you nothing illegal. You supposed to have the sole possession of it. They not supposed to take it from you. But in these situations right here, you playing with the United States of America. It's you versus the United States. When they want to play dirty, they're going to play dirty. And they don't care. They going to play dirt. It's not fair when you get in this situation. It's not fair at all. I want people to understand that, man. You think it's fair, but it's not fair. They are going to play the game how they want to play it. They give you what they want to give you. Yeah, you supposed to have it. Yeah, it's your right, your due process, but they don't care about your due process when they got you in there. It's millions of people locked up, man. Come on, man. Man, they don't care. And they running the ship how they want. This is why, all that gangster shit these niggas is out here portraying, nobody wants to deal with this part of it. When, in all actuality, this is a part of the game. This is a part of it. But don't nobody want to deal with this shit. Don't nobody want to be handled like this. But everybody want to be out there playing the game. Straight up. For a long period of time, I did not have a complete copy of my indictment, even though my counsel tried repeatedly to send it. I did not actually obtain a copy of my indictment until December 2025. Woo! Woo! You hear that? Wow. Straight up. Crazy. It's crazy. Appreciate that membership, D Twins. Whack been working. And no 60 members slide. Lining these jokers up. Big U just got his indictment December 2025. Been locked up since March. It's going on a year. Wow. On January 1st, 2026, when I suddenly and abruptly moved to the special housing unit with zero knowledge as to a reason why I lost access to my indictment and other legal papers. Wow. Wow. So he just got his indictment in December and they moved him January 1st and they confiscated it. Man, you can't tell me they ain't playing dirty. You can't tell me they ain't playing dirty, man. At an earlier detention proceeding, the government referred to a recorded calls and to issues related to legal mail, although they are allegedly a completely different entity than MDC, that caused me to be concerned that communications connected to legal matters might have been accessed or shared in ways I did not understand. As a result, I have become hesitant about freely discussing case strategies over the phone. I have submitted numerous cop-out emails and formal grievances about my missing and mishandled legal mail, and I have raised these issues verbally with staff, including at a highest level. The general response has been that there is no problem, with the notable exception of Officer Rena and Delgado on an email actually acknowledging that one item of legal mail was open outside of my presence. Woo! Seizure of USB and legal work product. On January 1st, 2026, I believe staff conducted a search of my cell and my property. During that search, they took my USB drive that contained discovery materials provided by my attorneys, as well as my handwritten legal notes, drafted, researched, and other defense work product. They playing dirty with Big U, man. Straight up. They playing dirty with Big U. They playing dirty. Yeah. They letting Big U know that this ain't no fair fight. They're letting him know that this ain't no fair fight. This how we playing. Nigga, we gonna take it and do what we want. Who you gonna call? Who gonna do what? Nigga, you in our world. All that on 6-0 in the neighborhood don't mean nothing when they get you in their world. I don't understand why people out there in the streets don't understand that at this point. After we see this happen to multiple people, that this how they handle you, they don't understand that. Ain't no more 6-0 this. It's we gonna do what we want with you because we own you. You are our property. You're property of the United States of America now. We gonna do what we want with you. We don't care what nobody say. It's a dirty game. To my knowledge, the USB and those legal materials were not inventoried. When I asked about them, staff had not acknowledged that they existed or that they were taken. They playing dirty now. Although my attorneys still possess copies of the discovery in their own files, the seized handwritten materials reflected my thought process, questions, observations developed over prior meetings. Without those personal defense notes, I cannot meaningfully build upon earlier discussions or recall what issues I had already arised or identified. Having counsel retain their own copies is not a substitute for my ability to retain and reference my own defense work product while assisting in preparation. Do you hear this? Hold up. They took all his notes from all the visits that he didn't have with his attorneys. They took all the legal stuff that he did have and said, sitting there and think about it. And then what they do is they see what angle you want to come at, and all they do is make sure that they corner that. So whatever angle Big U was trying to go at and say how he was going to defend himself, they're currently finding ways to go at that. It's not a fair game, man. It's what people got to understand. Straight up. The papers that were removed were clearly labeled as legal mail and attorney work product. They contained my own notes about what my lawyers had explained to me, thoughts about the evidence, and questions I had written down to discuss with the counsel. They took all that. On January 2nd, 2026, I telephonically notified my attorney, Peter Johnson, about my shoe conditions relating to legal documents as well as health topics. I also let him know I would be submitting a letter directly to you about various topics to which he did not object. The USB contained approximately 500 non-protected discovery files provided to me from my attorney. However, almost all of the most important discovery in this case is under a protective order. That protected material can only be reviewed when my defense team is physically present. Woo! That's how they playing. That's why Wack run around here. He don't care because he know Big U ain't gonna get the information. He know Big U ain't gonna never get it. You know, he know this is the game they playing. Big U ain't gonna never get the information. The seizure and non-return of my USB and legal items, including handwritten legal work, has cut off my ability to continue any of the prior work I had done to understand my case. I cannot go back to my notes, cannot track what we have already discussed, and cannot build on earlier sessions. In practical terms, I am forced to start over with almost nothing in my hand. Shoe placement and investigative status. Also, on January 1st, 2026, I was moved to a special housing unit at MDC Los Angeles. I was told this was administrative detention and that the stated reasons was not classified. I did not receive any incident report, disciplinary write-up, or hearing related to this move. To my knowledge, there was no finding that I committed a disciplinary infraction that required shoe placement. We want to break you. This is how they do the buck breaking. Since being in the shoe, my ability to meet and consult with counsel becomes much more limited. At this district is well aware, due to several attorney filing motions about this, legal visits require additional escorting and approval and have non-reported or advertised additional time constraints. There are therefore more delays and more uncertainty about when and how visits can occur. My access to legal materials in my cell is also more restricted. The combination of the suit placement investigation status and the removal of my USB and notes have made it extremely difficult for me to, in the future, have normal attorney-client meetings or to review materials in a continuous, organized way going forward. Contrary what I anticipate to be characterized as a challenge, I am describing the practical effects of this placement on my ability to participate in my defense, including restricted attorney access, loss of materials, and interruption of previous authorized accommodations. Regardless of this institution's reasons for placement, the resulting restriction materially affect my ability to prepare my case. Medical, chrono, and loss of CPAP and other accommodations. Before coming into federal custody, I was prescribed a CPAP machine for sleep apnea. MDC medical staff issued a Bureau of Prisons medical chrono authorizing use of the CPAP machine, a knee brace, and a 2-mattress accommodation. I also wear prescription glasses. Hey, listen. See, Big U doesn't understand that they don't care. You know, when people out here acting a fool, they don't understand that these people don't care about your health. They don't care about your needs. They don't care about what you want. They care about processing this case and getting the conviction. This is all they care about, man. This is all they care about is a conviction. You know, all your other health issues and what you got going on don't concern them. What is concerning to them is a conviction. We got the conviction. This is our job. Our job is not to make you comfortable. Our job is not to accommodate you. It's to put you in the system and lock you away. When are people going to understand that that is how they're thinking? Come on, man. Pay attention, man. It's a dirty game. You know, Big U thought, I guess he thought he was going to be able to slide through. They can't mess with me. They can't do nothing with me. Shit, they got a place for you now. Understanding that. Crazy. After I was moved to the SHU on January 1st, 2026, my CPAP machine and plug were taken. I was allowed to use the CPAP briefly, but then it was taken away again. Since that time, I have repeatedly requested that it be returned and have explained that I am worried about serious health consequences if I go without it. But frankly, death can occur for those who require breathing machines when they sleep if they do not have one. Therefore, since being in the SHU without it, I simply cannot allow myself to fall asleep whatsoever. My additional mattress accommodation due to back and shoulder injuries and my eyeglasses have also not been provided in SHU. My knee brace was returned after a short period, but the lack of sleep support and proper bedding have made my physical discomfort worse. Without the CPAP and the full set accommodations, I have trouble focusing, and I feel physically worn down as can be anticipated. That makes it much harder for me to concentrate during future legal visits or to review the material I do receive. Do you think they care? Do you think they care that Big U is feeling any pain or discomfort? Not one bit. They don't care that Big U is feeling a pain or discomfort, that, his back and shoulder hurting and his knee hurting and his breathing, and they don't care about that. They care about the conviction. These are the things people don't think about when they out there running the street. They don't think about this now. You hear me? They ain't concerned about this now when they out there running the street, man. A $2,500 investigation hold has been placed on my inmate trust account. So now they done froze the paper. Whoa, they done froze the money. I was not given an explanation for why this hold was placed or what event or investigation triggered it. So now they don't even want to let Big U go to commissary. They done froze the money. Nah, you ain't doing nothing. We ain't accommodating your pain, what you're going through, your sleep. We don't want you to have no commissary food, no nothing. This is what they doing now. Such a hold is a hinder to a person's ability to purchase commissary items such as food, hygiene items, and with the ability to use a computer system such as Core Links that I also rely on to coordinate regarding my defense when I was not in the SHU. They don't want you to have no commissary, no nothing. They want you to feel this. They not playing fair, man. Big U ain't understand this while he was on the street. Attempt to resolve these issues internally. I have tried to address these problems through the channels that are available to me. I have submitted multiple cop-outs. I have filed a BP-8 informal resolution and a BP-9 grievance. I have sent a grievance to the regional director. I have even contacted the Postal Service about the mishandling of my mail. For some examples, I have raised these issues verbally many times with staffs in my unit, with the supervisors, including at the warden level. The general response has been to say that there is no issue or to not take any corrective actions. As of the time of this declaration, the USB and legal papers have not been returned. My discovery access remains extremely limited. My mail problems continue, and my medical accommodations are still not provided. Access and prejudice to defense preparation. This is not a complaint about comfort, inconvenience, or general detention conditions. The conditions described are directly tied to my ability to see evidence, understand the government's allegations, and communicate with counsel in a continuous and organized way. In other words, these conditions affect the core constitutional rights to participate in my own defense rather day-to-day living conditions. Because my USB and notes were taken, and because I am in SHU and under investigative status, I do not have ongoing access to discovery that would allow me to understand the government's evidence or assist counsel in developing strategy. The problem is not that there has been too little time on the calendar. The problem is that under these facts, conditions, and restrictions, there is no realistic way for me to prepare no matter how long the case is continued. Defense resources. I do not claim that my attorneys have acted in bad faith in any way. However, as a detained defendant in a very large RICO case, and based on these circumstances and the restrictions described in this declaration, I respectfully submit that my current defense resources are not realistically sufficient to allow me to meaningfully participate in my defense or to adequately assist counsel within the practical limits created by my detention conditions and limited discovery access. According whether or not the trial is continued over my objection, I respectfully ask that the court consider authorizing the appointment of additional CJA resources, including 2 additional attorneys, 3 additional investigators, and a cell phone tower and communication data expert, so that my defense team has the capacity to review the discovery identified and interview potential witnesses and prepare the case in a manner consistent with its scale and complexity. So he wants more attorneys. He wants, to be able to, have cell phone information and towers, data experts. And I don't think they're going to accommodate him on extra attorneys. Nah. Now you got this one attorney. We give you the right to counsel, and that's it. That's all we doing. We ain't doing all that. This how they handle you now. People got to understand this, man. This is something that, people should highlight. Share this live. This is something that people should highlight, because everybody that talk like they on that and they about this life, this is the process. But don't nobody want to pay attention to this part of the process. This is what happens. They get you in a situation and they do what they want with you. And don't nobody care about how you feel. You got your family that care. They might be writing and calling, but they going to talk nice to them on the phone and mislead them. This is what they do. People don't pay attention to this, man. This is what they do. Straight up. This request is not made for the purpose or delay. And if it would result in a delay, I revoke the request. I continue to assert my right to a speedy trial. I make this request because under the conditions described, meaningful preparation cannot occur without increased defense resources regarding whether the trial date is continued or remain as set. Remedy and opposition to continuance. I want the court to know that I am not asking for a continuance. I am not asking the court to delay the case so that I can have more time. I do not want the delay. I have obviously made clear I want a speedy trial on many occasions, and that has never nor will ever change. Absent the opportunity to be granted bond so I may meaningfully participate in my defense confined to my home and without restrictions listed. The conditions I have described are not the kind of problems that can be fixed by moving the trial date. They arise from the seizure and non-return of my legal materials, from shoe placement and investigative status, from mail and communication barriers, now from the loss of my medical necessary equipment, and from the failure to follow even a court order related to my son's death. If the trial date is pushed back, but nothing changes about these conditions, I will still not be able to see the discovery. I will still not have my notes and materials. I will still be under unreasonably restrictive conditions, and I will still not be able to participate in preparing my defense. You know what I want to tell people, right? When you dealing with people out in the streets, right, and they cooperate against you, right, and they're a confidential informant, you know, like Wack, right? When there's people that are confidential informants, straight up 137 informants, they play these discovery games with you, straight up. And you know, it's crazy that it says in the law that they don't gotta provide you the discovery directly to you if they're trying to protect informants. Straight up. That's what's wild. So they want to protect their informants. You know, Wack is running around here doing what he do, right? Niggas still gravitate to him. They still rock with him, right? But of course, they're trying to protect individuals, right? And we all know what happened. Loose Cannon corroborated the story through Wack. He told Wack all the information. They got the information from Loose Cannon and Wack. They got information from the sources that they had taking the money to Big U, and he was taking the extortion payments. It's a lot of evidence that they have that they want to play games with Big U and not give him the evidence. Straight up. The game is dirty, man. And, you know, this is what people do not prepare for. They don't prepare for this, man. When you got to understand, this is a part of the game. We don't think about this when we out in the street. This is a part of the game. It's so many people going through this same thing. We only know about this because it's Big U, and we talking about it. Straight up. We only know about this because it's Big U. But there's plenty of people going through this, that they keeping the paperwork, they taking your legal mail, they forcing you to do this and do that. They don't care. Man, life ain't fair on no level. You're not free in the world, and when you get in these situations, you're really under the custody of them. You at the leisure of how they want to handle you. Straight up. Additional delay would increase the prejudice I am already suffering. It would prolong my detention under conditions that prevents meaningful discovery review, that limit communication with counsel, and that have already resulted in failure to follow a court order in connection with the death of my child. These conditions did not exist at the time of my original or subsequent detention hearing. The shoe placement, investigative status, seizure of my legal materials, and the USB on January 1st, 2026, the continued legal mail issues, the restriction of my trust account, the interruption of my medical chrono, and the way the court order concerned my son's death was handled are all developments that occurred after the hearing. They are materially changed circumstances that directly affect my ability to prepare for my defense and my experience of detention. I also understand that the court has the authority to reconsider detention or modify condition of custody when material new information comes to light that did not exist or was not available or brought up at the time of a prior detention hearing. The fact described in this declaration arose and have had a direct effect on my ability to review the discovery, communicate with counsel, and participate in my defense. I respectfully submit these developments for the court's awareness, and I understand that the court may, if I believe appropriate, reopen or review my detention status on its own motion. I respectfully request that the court be aware that I no longer have access to my prescription reading glasses, and that I therefore require larger print materials to meaningfully review case documents. In particular, I understand that the government produced an update and complete discovery index with descriptors on August 13, 2025, as referenced in the docket number 737, page 10, line 17 through 18. If the court finds it appropriate, I would welcome clarification regarding whether I have received and retained a complete copy of specific index in 14 or 16 point font prior to the leaving the courtroom or courthouse on or about the next scheduled hearing date of January 6, 2026, and that it may not be confiscated by custodial staff as if legal material directly related to my case. I am not requesting production of discovery materials themselves. I am requesting only the discovery index with descriptors, which I understand is not subject to the protective order. If I do not receive it in font of you or have relied on mail or attorney Dropbox at MDC as fully detailed, I will not receive it. I have told attorneys about everything within this letter to you prior to submitting this letter. I respectfully advise the court that my current SHU commissary options are incompatible with my religious and restrictive diet, as the SHU commissary list provides only 2 consumable items. The general commissary list contains a significantly bordered range of basic food options. I ask that the court be aware of these circumstances, and if the court believes it is appropriate, I would welcome a recommendation that I be permitted to purchase food items such as noodles, soup, cereal, and beans from the general commissary list while I am in SHU. I further advise the court that in the SHU, it is my understanding that one call is permitted monthly. And in my first attempt to call my family since being here today, it stated that I have no more minutes to use, and I could not do so. I have asked the SHU staff multiple times to call my attorneys, and the request has not been honored. I have submitted a cop-out regarding being taken to the SHU without due process or even an understanding as to why. I respectfully inform the court that since my transfer to SHU, my CPAP access has been inconsistent, even though I rely on it whenever I sleep, and previously I had continuous access pursuant to medical authorization. I ask the court to be aware of extreme medical risks associated with current limitations. If the court finds it appropriate, I would welcome clarification or direction to MDC to ensure that the CPAP access is restored and that compliance can be documented to ensure the accommodations is implemented. I inform the court that I have asked no less than 5 times that attorneys be added so I may call them without using my allotted minutes, as is customary at MDC, and this request has been repeatedly denied. My family has repeatedly called due to concerns since January 1st, 2026, and been told that they can't speak to the warden, nor will any information be provided to them about my status. 4 people can declare the same. I also informed the court that my mattress accommodations has not been consistently provided since my placement in the SHU. They result in pain and sleep disruption, further affect my concentration and ability to participate in my defense. I respectfully submit this for the court's awareness, and if the court believes appropriate, I would welcome clarification or direction to MDC to ensure the accommodations implemented and documented. Given the cumulative impact of these conditions on my ability to prepare and participate in my defense, I respectfully ask the court to be aware that these circumstances may warrant development of a more formal record regarding access and confinement conditions. Should the court determine that further inquiry is appropriate, I respectfully inform the court that my legal material and handwritten defense notes were seized and have not been returned to me. I do not know their present status, such as whether they are already disposed of or copied for the government to preview my defense. I submit this fact for the court awareness and would welcome any clarification and direction to the court believes appropriate regarding their status of return. Finally, I respectfully state that I do not wish to waive my physical presence at hearing, particularly any hearing that may involve continuance or my trial date or matters affecting my ability to participate in my defense. To the extent a prior electronic waiver appeared on docket, I clarify that it does not reflect my present intent. I am not seeking delay. I am asking for the opportunity to defend myself fairly. I declare under penalty of perjury under the law of the United States of America that the foregoing is true and correct to the best of my knowledge, because this declaration was prepared at my complete direction and then submitted at my specific request via U.S. mail and also email to avoid delay under the time constraints of the next hearing. I respectfully reserve to the right to supplement or clarify these statements as needed. Executed January 4th, 2026, Los Angeles, California. Eugene Jr. Eugene Henley Jr. Hey, listen, man. They not playing no games, man. This is what people got to understand. They don't care about nothing you talking about. Yeah, we do got rights. Yes, we supposed to have due process rights. But when they get you in their custody, they don't care how they treat you, man. They don't care about none of that.